false evidence, fabricated evidence, forged evidence. A tainted evidence is information created or obtained illegally to sway the verdict in a court case. Falsified evidence could be created by either side in a case, or by someone sympathetic to either side. Misleading by suppressing evidence can also be considered a form of false evidence. However, in some cases, suppressed evidence is excluded because it cannot be proved the accused was aware of the items found or of their location. The analysis of evidence may also be forged if the person doing the forensic work finds it easier to fabricate evidence and test results than to perform the actual work involved. Parallel construction is a form of false evidence in which the evidence is truthful but its origins are untruthfully described. At times, in order to avoid evidence being excluded as inadmissible due to unlawful means of procurement such as an unlawful search. Apart from the desire for one side or another to succeed or fail in its case, the exact rationale for falsifying evidence can vary. Falsifying evidence to procure the conviction of those honestly believed guilty is considered a form of police corruption even though it is intended to result in the conviction of the guilty. However, it may also reflect the incorrect prejudices of the falsifier, and it also tends to encourage corrupt police behavior generally. In the United Kingdom, this is sometimes called noble cause corruption. A throwdown, i.e., the planting of a weapon at a crime scene, might be used by the police to justify shooting the victim in self-defense, and avoid possible prosecution for manslaughter. However, the accused might have falsified some evidence, especially if not arrested immediately, or by having other access to a crime scene on related areas. Types: forged evidence, an item or information manufactured or altered to support some agenda, is not admissible in many courts, including U.S. criminal courts. Planted evidence, an item or information which has been moved or planted at a scene to seem related to the accused party, is not admissible in many courts, including U.S. criminal courts. Tainted evidence, information which has been obtained by illegal means or has been revealed using evidence acquired by illegal search and/or seizure, is called the fruit of the poisonous tree, and is not admissible in many courts, including U.S. criminal courts. Parallel construction, tainted evidence, where the origin of the evidence is untruthfully represented, preventing discussion of whether it was legally obtained or not. Suppressed evidence, an item or information which a court judge has ruled as inadmissible, is forbidden to be presented in a court case. Suppressed evidence might be excluded because it was found hidden or locked away in areas the accused could not be proven to know. In some criminal cases, a person will be identified as a person of interest for a few days before arrest, allowing time to reveal suspicious actions, or to attempt to falsify evidence before their arrest. A type of falsified evidence, used to acquit, would be faked sales receipts which indicated activities had occurred elsewhere during the time of the crime. Cases: the Crew murders in June 1970, Apukekawa, Lower Waikato. Couple were killed and the bodies dumped in the Waikato River. Arthur Allen Thomas, a local farmer, was twice convicted of the murders but following massive publicity was later given a royal pardon. Two bullet cases presented by senior policemen Hutton and Johnston were crucial evidence for the conviction. In 1980, after Thomas's pardon, a royal commission into the convictions concluded Mr. Hutton and Mr. Johnston planted the shell case, Exhibit 350, in the Crew garden, and that they did so to manufacture evidence that Mr. Thomas's rifle had been used for the killings. Murder of Holly Skater in 1992. 11-year-old Holly Skater was raped and murdered while babysitting in Waukegan, Illinois. A local man named Juan Rivera Rivera was convicted of the murder solely on the basis of a confession, one that he claimed was coerced. No physical evidence linked him to the crime scene, and many details of his confession contradicted known evidence from the crime scene. DNA testing done in 2004 on semen taken from the crime scene ruled out Rivera as the source. However, the prosecution argued that the semen sample came from previous consensual sex with another man. Rivera was convicted again. His conviction was overturned by the appellate court, who took the unusual step of barring prosecutors from retrying Rivera, and he was released. After his release, Rivera's attorneys asked the courts to order genetic testing on a piece of evidence the prosecution had tried to use at his trial in 1993. Rivera's shoes had blood on them, which the prosecution argued belonged to Holly. The prosecution withdrew them prior to his first trial when it was discovered that the shoes were not available for sale anywhere in the United States until after the murder. In 2015, Juin's attorney sought further forensic testing on the shoes. DNA analysis indicated that the blood indeed belonged to Holly, but also contained another genetic sample, one that matched the semen sample. Rivera's defense team insists that this is proof not only that the blood was planted, but that the real killer's DNA was inadvertently planted as well. The DNA has yet to be matched to an individual, but has been linked to DNA from another home invasion and murder. The man convicted of the crime also claims to be wrongfully convicted. Following his exoneration, he was awarded $20 million USD, the largest wrongful conviction settlement in U.S. history. New York State Police Troops scandal. In the New York State Police Troops scandal of 1993, Craig D. Harvey, a New York State Police trooper, was charged with fabricating evidence. Harvey admitted he and another trooper lifted fingerprints from items the suspect, John Spencer, touched while in Troop C headquarters during booking. He attached the fingerprints to evidence cards and later claimed that he had pulled the fingerprints from the scene of the murder. The forged evidence was used during trial, and John Spencer was sentenced to 50 years to life in prison. After the truth came out, it was discovered that they had been falsifying evidence in cases for many years. At least 3 officers were convicted. Every case the department had been involved in had to be reinvestigated. FBI scandal. In the 1990s, the fingerprint, DNA, and explosive units of the Federal Bureau of Investigation Laboratory had written reports confirming local police department theories without actually performing the work. Such laws and regulatory procedures stipulating the conditions under which evidence can be handled and manipulated fall under a body of due process statutes called chain of custody rules. It is crucial for law enforcement agencies to scrupulously collect, handle and transfer evidence in order to avoid its falsification. In most jurisdictions, chain of evidence rules require that the transfer of criminal evidence be handled by as few persons as possible, to prevent error or improper tampering. Chain of evidence rules also stipulate that those authorized to experiment with collected evidence document the nature, time, date and duration of the handling. Iraq and Afghanistan wars. In the wars in Iraq and Afghanistan, soldiers have been known to place weapons on a near a slain individual to make that person appear to be an enemy combatant or insurgent. Alternatively, a dropped weapon or other item is left in the open. Any individual who picks it up may be fired upon, a process known as baiting. The use of drop weapons has been the cause of some controversy in the Iraq War. In 2008, 3 United States Army soldiers were found guilty of planting evidence in this way. One of them, Sergeant Evan Veller, was also sentenced to a 10-year prison term for murder of an unarmed Iraqi. A military court found that on the 27th of April 2007, Specialist George Sandoval shot an Iraqi man on the order of Staff Sergeant Michael Hensley. The two men then placed a spool of wire into the pocket of the dead man, who had been cutting grass with a rusty sickle. Hensley and Sandoval were charged with murder, of which they were acquitted, and with planting evidence, of which they were found guilty. The asymmetric warfare group is said by Captain Didier to have sent boxes of the kind normally used to hold ammunition filled with drop items to his unit, the 1st Battalion 501st Infantry Regiment, in order to disrupt the AIF attempts at harming coalition forces and give us the upper hand in a fight. The Independent newspaper quoted a spokesperson for the U.S. military as saying, "There are no classified programs that authorize the murder of local nationals and the use of drop weapons to make killings appear legally justified."